Good morning, group.
Good morning, John. Good morning,
This
Steve.
is week 8 of It's Your Money, and it's the last session of it, except it's a state, it's not money. We've been having a real entertaining time for those of you who are just now coming in and joining us in terms of mechanical issues and other kinds of issues. So we're ever so slightly dingy here in terms of where we are at the moment. So it is week 8 of It's Your Estate, and this is going to be a review. We do not have a charity present today, so Pete's going to jump right in. And what I'm going to do is I'm going to disappear as I always do. And you're honestly, please, going to use Q&A, not chat. And Q&A, I will be reviewing along the way and either answer you, or I will leave it there for Pete to answer, or we'll do it at the end of the session. So I'm going to disappear and occasionally appear back
Don,
again.
Is
Yes, Pete.
Yeah,
We're recording. Go ahead.
Yeah. Is it feasible to bring up the participants?
If you click on see them, no.
No, I mean have them, because we have a small number. I was thinking that maybe we can have a kind of a more of a participatory session. Probably not.
We cannot convert this to meetings, so we can't simply say, hey, everybody come on in.
Yeah.
The only trick to that would be trying to release them and not release them along the way.
Yeah, no,
And
never
I don't
mind.
think that would be very pretty.
Well, anyway, the reason why I'm saying that is that this is the last session. We've had previous 7 weeks. We've gone through what is a will, what are the documents that you need, what is probate, and so this is the time for questions. And Dawn is going to review those questions as they pop up, and will interrupt us as needed. And so the voice of God will be heard for the last time
For this season. My guess is we will be back in the spring. Incidentally, well, I have the platform. Question has been asked several times of how long do the recordings stay on the site? And the recordings are the same place you get where the materials are. Probably Monday or Tuesday, this version will be posted, and they will remain there until the spring. When we have new material in the spring and have thought of new things to say, then we will create new videos, but they will be there until then. So don't worry about them disappearing, but I am going to disappear.
All right. It's about time he disappears. You know that, Steve? It's just
Thank you,
and I now. Oh, you're still here.
Apparently he doesn't turn off his volume.
Yeah. Steve, why don't you bring up your ask first form?
Okay, let's see if I can get that to work. Okay. Can you see it there, Pete?
Yes, I can.
Okay.
You've got a master's other advanced degree, and I'm assuming that's your Juris Doctorate.
Correct. So that's a law degree. And I've been an estate planning attorney for, it says 22 years on there, but it's closer to 23 these days. So
and so you're pretty much your entire time as an attorney has been in the estate planning area?
Yes. Yeah. No, I've practiced in the estate planning and related fields for my entire career.
Okay. I think that's really important to know from an attorney. You do practice law here in California, and if we need to look you up, you've got the your license number and business relationship. You put your client's interest first. So how do you charge, Steve?
So for a lot of estate planning, like doing a trust, a will, power of attorney, healthcare directive, we can charge a flat fee. And that ranges, I'd say, between $1,500 to $2,500 for probably 90% of my clients. The factors that kind of go into cost are you married? Are you single? What's the value of your estate? How many real properties do you have that we would need to do deeds for and things like that? So
do you charge for putting a property into the name of the trust?
I generally include that in whatever the basic fee is, transferring any, at least California real estate into your trust. Sometimes when you have properties in other states, we need to get a local lawyer in that state to prepare a deed to transfer that in, and whatever that cost might be is not included.
Okay. And then what's your hourly rate? Oh, I see it on there. It's $385 an hour. Do you practice the hourly rate when you're doing a restatement or trust administration? Is that where the hourly rate comes in? And how do you tell people what that hourly rate is? And how do they figure out what is the total cost? I think that's one of the more difficult things for a consumer to figure out.
Yeah, and I have a lot of sympathy for that as well. So my hourly rate is $385 an hour. And so for, if we're doing like a simple amendment that might only take an hour, or if you're retaining me to assist with the administration and distribution of mom or dad's trust, those are the types of things, or litigation involving an estate that we would charge on an hourly basis. It's often difficult for us to give a real precise estimate as to what the total cost all in will be. I still don't think that's an unreasonable question to ask, and I think it's fair to ask your lawyer, what do you think it's going to be? And I'm always happy to give my best estimate as to where we'll be. For example, if someone comes in and says, "Hey, I'm an only child, mom and dad died. Can you help me distribute the trust and do what I need to do?" Well, in that case, it'd be pretty simple. I'd say, maybe a couple $1,000, to get that done. If you come to me and say, "Hey, mom and dad had a, $50 million estate. There's multiple beneficiaries. We've got continuing trusts for kids and grandkids." I might say, "Hey, assuming there's no litigation, we're looking at, $20,000 plus." So just to kind of give a couple examples there.
Should people go back to the legal counsel who drafted the trust? Is that for making changes or to do trust administration? Give us a little thought on that. I know there's no right answer.
Well, I'm always happy to give my thoughts. So, if you're doing an amendment to your trust and you have a lawyer who did your existing trust, I think it ultimately would be more cost effective in most cases to go back to that same lawyer to do a change. I think what's most important is you need to be comfortable and happy with your lawyer. And if you're not, you should look for a new one. Whether or not you should go to your parents' estate planning lawyer to do the trust administration, that happens a lot, but really there's not a huge advantage to doing that. So if you have another lawyer you like, or you prefer, or one that's maybe closer to you geographically, I would say, pick whatever lawyer you like the most, who will do a good job for you, and so forth.
And
Steve, let me ask you a question.
Sure.
It always comes up along the way, so I'll ask it ahead of time. So I just moved to California from some other state, whatever state it is. I had a trust. I was really happy with it. Now that I'm here, do I have to have it redone? Answer the question is yes, in some form, because it's state specific. Do you start from scratch, or does this, are you going to charge me the same as if I had nothing, or why don't you just make an amendment for me?
Yeah, I'd say most estate planning lawyers, if you have an out-of-state trust and you want to make some changes to it, and Don, I will disagree just a little with your last statement. Some out-of-state trusts are okay. Where you run into issues is, many states are separate property states, and they come in where husband and wife have separate trusts, and sometimes that doesn't work as good in the context of California. But I'd say, if you come from another state, it's not a bad idea to have a California lawyer review just to make sure your trust is okay. If we're going to do a new trust and you come in with or an amendment and you come in with an out-of-state trust, most likely we would do an amendment and restatement of the whole trust, just to make sure everything's California dialed in. The other issue that comes in if you've moved here from out of state is some of the the Advanced Healthcare Directive. California has its own form for that. Not that the out-of-state form won't work, but sometimes it's just nice to have the local form that our doctors and hospitals are used to seeing, as an example.
Yeah, some of the things are practicality. Let's go to the outline for today.
Okay, I'll bring that up, Pete. Let me scroll back up to the top here.
There you go. It's your estate, week 8. Did I spell your name correctly there, Stephen?
You do not, but that, I get it a lot, you know.
My apologies. I just noticed that.
Or just go with the, everybody calls me Steve, so that works as well. So, but even though I call you Pete, you have Peter up there. So I guess that was your thought process. Yeah.
Okay. What we, since it's a review, we really highly recommend using the Ask First form. It gets you, in completing this, the Ask First form, Steve, how long did it take you?
5 minutes.
5 minutes?
Yeah.
Were you offended by any of the questions?
No, and I think if you ran into a lawyer, and whether you use the Ask First form or you just are very clear about what's your rate, how do you charge, what do you estimate, all in this is going to cost, is there anything that's not included? If they quote you a flat fee for estate planning, that's very important to ask. Or do you charge separately for photocopies or postage, things like that can add up. If you run into a lawyer who's offended or rubs you the wrong way answering those questions, I think you'd want to look elsewhere. Yeah.
There's plenty of them out there.
I'd say most think there's too many, yes.
Yeah. Well, we won't go into those jokes, okay?
It's okay. I'm willing to be the butt of those jokes if necessary. Yeah.
But it's the primary area of practice. We always ask the attorney that. What is your hourly rate? Do you have a set fee for the estate planning documents? Do you charge extra for transferring the real estate to the trust? Check out the attorney on the California bar search. It's easy to do, takes you 2 minutes. Check with 3 different ones, at least with a quick phone call, so you get some kind of idea. The last thing you want is to be in front of an attorney and get a bill and you don't like him or her. So and there is no one way that attorneys charge. Everybody charges a little bit different and has different fees. The more ethical ones tell you right up front as to what the approximate cost is going to be. And if you think that's too much, sometimes they'll even negotiate with you if you're a nice person. So don't be rude.
To fame, Pete, it was a client who attended one of your classes, met with me, husband and wife, very nice couple, and they said, you are the 22nd attorney we have interviewed.
Wow.
I couldn't believe it. I said, wow, I feel sorry for you having to go through all those. And but I won the contest, which was that's my claim to fame here. But or maybe I was just the least expensive. I don't know. They didn't really tell me why, but you want to feel comfortable with them. Communication, Pete. You've dealt with lawyers a lot. Is a huge part of it, and that's the number one complaint that I hear about from clients who maybe have used other lawyers is, I call them, they don't call me back, or all I'm only dealing with is their assistant, and I can't talk to the actual lawyer. So things like that, to the extent you can get a feel for it up front, ultimately will lead to a better experience if you get a good feel for that.
Okay. Basic estate planning documents. It's going to be a will, a durable power of attorney, the Advanced Healthcare Directive, and we're going to be talking about a living trust. All of these documents transfer legal authority to another individual. And if you don't have these documents, where is the legal authority come from, Steve?
It has to come from the courts, so you ultimately, it requires either a probate if after someone passes away, or if during lifetime, a guardianship or conservatorship. A lot of people think that, well, just being the spouse of someone who's incapacitated or who dies, or being the parent of a minor who's a beneficiary, or spouse of someone who's incapacitated, gives you authority to get information from the bank, write a check on an account that's in your spouse's name, and unfortunately it doesn't. We need these documents to be able to do some of the things that we may need to do if a spouse or a loved one is incapacitated, for example.
So, yeah. So the first one we're going to talk about is the will. The most common type of will is going to be a pour over will. And what does that mean again, Steve?
So a pour over will is a will that you do in conjunction with a living trust. So if you have a living trust, you will also have a pour over will. And it just means that if an asset of yours, you forgot to put it in the trust or couldn't, your will names your trust as the beneficiary. The will pours over to the trust any assets that may not have gotten into your trust prior to your death.
And that's kind of why we consider this as almost like if you have a complete estate plan, that we considered it an emergency document. It's hopefully it's not, you don't need it. And I believe the amount that you could have in your own personal name and still avoid a formal probate is 166,000. Is that approximately correct?
Yeah, I think it's 166,500, and it's indexed for inflation, so it goes up a little each year. So maybe January 1st will go up a little bit, but
but it's so important for you to know how you have title to assets. So I suggest taking out a sheet of paper, listing your assets on one side of the paper, looking at how you hold title, add in cost basis, and then add in market value. And we'll show you that a little bit later on. But depending on how you have title will determine what document that you need. So during your lifetime, you want somebody to act on your behalf. We may, by the way, can you use a will for anything while you're alive?
No, it's only good, at your death. It's a document that only comes into existence it only has legal effect at your death. So.
Yeah. So it has no effect at all during your lifetime. The document that becomes really important is that durable power of attorney. And the person who's acting with legal authority on your behalf is called an attorney in fact. And do they still use the word durable in these documents, or how do they describe that?
They still do. I don't know that it needs to be in the title, but that just means that your power of attorney survives incapacity. So, which seems counterintuitive how most people think about powers of attorney, which is I need it when you are incapacitated. An actual non-durable power of attorney, which you almost never see, actually loses legal authority when you do become incapacitated. So it's important that it be a durable power of attorney. You just want to make sure if you are getting a form online that it says that it survives your incapacity.
Those are kind of the word. Those are the words that are usually used inside the document. Survives incapacity or is good through some sort of incapacity.
Yes, you'll see language to that effect. Yep.
Okay. Well, we got two major types, immediate or springing. Talk a little bit about that.
Yeah. So, an immediate durable power of attorney is one that takes effect the minute you sign it, even if you still have full capacity, which you would if you signed it. And a springing durable power of attorney is one that doesn't grant that legal authority to your attorney in fact until you become incapacitated. So, I know you and Pete and I, we've talked about this in the past. We definitely prefer the immediate power of attorney because a springing power of attorney comes with it an obligation to get a doctor's opinion of incapacity before you can use that power of attorney. And in many cases, those can be difficult to obtain. And I've seen powers of attorneys that require 2 opinions, sometimes even 3, which can bring further challenges with it. So,
yeah. So take a look at your durable power of attorney to see if it's an immediate or if it's springing. If it's springing, which is what probably 90% of all attorneys used probably around 10 years ago, a different time period. Today, I'm recommending, and I'm glad you're recommending as well, Steve, that the immediate, unless there's some particular issue that warrants a springing, and that's something that you need to talk to the attorney about. But would you give us a document to all your children to keep one in the car, you know, have it available?
Well, generally no, but
Yeah.
but it kind of depends on what stage of your life you're at. So, and you know, the family dynamics and everything else. If you're concerned that someone might take your immediate power of attorney and go down to your bank and write a check, then yeah, you don't need to give them a copy of the power of attorney. No. The solution is, you know, number one, we could do a springing to protect you, but probably the easier, more convenient is you just tell your agent or attorney in fact where they can find it. Okay. Exactly. Or, you know, you can give them your attorney's name. They will have a copy in most cases, so that they can get access to it if someone needs to, in order to like pay your bills or manage your finances.
Yeah. When this document comes up a lot is that for having one spouse is in the hospital or sick or can't get to it, and the other spouse needs to, for example, get an extra withdrawal from your commercial annuity, or they need a withdrawal from your 401k or your 403b or 457 plan. These items are usually not in the name of the trust, so they're in your personal name. And the only way another individual can get at it is that if they have the legal authority through the durable power of attorney to get into that document. And that brings up to financial institutions. Do financial institutions love your documents, your durable power of attorney, Steve?
No, I think they see a lot of fraud with powers of attorney. So they're very resistant and make you, you know, dot your I's and cross your T's and run it through their legal department. And then even after all that, sometimes they just reject your power of attorney because it's old, you know, 10 years, 20 years old. And this is despite the fact that California law is very clear that, you know, they have to accept a valid legal power of attorney, no matter how old it is. But they, in cases, and I know you've seen them, you know, basically force you to go get a court order confirming the validity of the power of attorney.
Yeah, and you don't want to have to do that because usually the reason why you're trying to use it is because you need the money. So
yeah, there's usually some, you know, emergency or at least something that has some time pressure on it to pay a bill or something on behalf of someone else, a mortgage payment, property taxes, things like that, you know, where it comes up. And, you know, there's a couple ways to address it. You know, one is, you know, take your power of attorney to your financial institutions before it's needed and ask them to basically say, yes, we will accept it. And then, Pete, I know you've found, and many of my clients have as well, is a lot of financial institutions have their own form that they want you to use for a power of attorney. So the another alternative is to fill out the power of attorney form that they have right at the bank or the financial institution, because you know they will accept that one if it ever became needed.
Yeah. And remember, when you're dealing with a bank or with a brokerage firm, you're not dealing with an attorney, you're dealing with a clerk. And so they don't know the law. So ask them if they have an in-house durable power of attorney form that you can complete, and will they accept yours and electronically put it in your file? It'll save an immense amount of headaches when it's needed. The only thing is that may want to jot down on a post-it note or something in your estate planning documents which bank accounts that you have, or IRA accounts, financial institutions that you have completed their format. Because if you intend to change, i.e. your the individual that you had named to be your attorney, in fact, moves away, or you get a divorce, now you've got competing durable powers of attorney forms, and that's even more of a big headache than not having one. So, but these documents are really, really important. So the durable power of attorney is one of the, it impacts you during lifetime. And that's why it's so important.
Yeah, I think durable power of attorney, and we'll talk about it in a second, the healthcare directive, are very underrated, documents. What I often tell clients is, if someone passes away and we have to go through probate, you're gone, you don't have to worry about it. Usually your beneficiaries, in most cases, the assets will still end up where you want them. Maybe they had to spend a little more money and take a little more time to get them in probate. But with the power of attorney, or in the event of incapacity, if we need a power of attorney or a healthcare directive, incapacity can last, and I've seen it for years, in some tragic situations where young adults or children are incapacitated, and they, the conservatorships last for, tens of years.
Yeah.
That a lot of that hassle and expense can be avoided if these documents are in place.
Yeah. And you can, a will, you can pick up a will for a statutory form from the internet. So just make sure you don't write on it, just complete the fill in the blanks. You can also get a durable power of attorney from the internet, but I don't really recommend it. If you just want to get a durable power of attorney, see an attorney, because these are so powerful documents, and you want to make sure that they're done correctly.
Steve,
and do you? Yes.
Steve,
Yes.
what happens to a durable power of attorney when you die?
So the durable power of attorney basically loses its validity upon death. So an agent under a power of attorney, or I'm using the word agent, as Pete correctly noted, attorney, in fact, is actually the official name, loses legal authority under the power of attorney when someone passes away. So, a lot of people think those still come into play. That it is sometimes relevant for just dealing with some funeral issues and some other things that in the healthcare directive. But as far as financial assets, as soon as a person passes away, you no longer have authority under a power of attorney.
Because then it either goes to will or trust or whatever else it might be. Because I know there are parts of an advanced healthcare directive that do carry over, such as funeral. Okay. Thank you.
And I've seen it in other cases where they're dealing with the the coroner's office, and they'll accept some authority using under a power of attorney, to make some very preliminary decisions about what to do in that situation. But as far as the financial side of things, when the person passes away, the power of attorney goes away with them.
Yeah, but the question I received yesterday was from an individual. How does the state or the federal government know that you've died? And when you die, it's recorded by the county, and which goes to the state, also goes to the Social Security Department, and it gets recorded, and you can't do anything on behalf of another individual who is deceased without a death certificate. So
Yeah, I mean, the financial institutions typically don't find out until they're informed about it.
Yeah.
But yes, the federal government, the state of California, the county, they all know. As you know, I had a client come in, oh gosh, it was probably 15 or 20 years ago, is when the estate tax exemption was changing. And his dad died on December 31st, at like 10 in the evening. And if he would have died 3 hours later, it would have saved him a couple $100,000 in estate tax because the exemption was changing. And so he was in my office trying to figure out how we can change the date of death on the.
Impossible.
It was impossible. Yeah, there was nothing
Nobody's
to do. In that regard. So
yeah. And if Social Security, if they made a payment that month, by the end of the month, that payment will leave your account. So they're very much on top of it. But financial institutions, you have to inform them. And so a lot of times people with the durable power of attorney, I get the question, hey, the bank doesn't know mom has died yet. Is it okay if I go down to the bank and use my durable power to get some money out? And the answer, of course, is no, you can't. Upon death, that authority ends. And if there's a conflict sometime down the road and people find out that you have taken money out without having legal authority, that's fraud. And so it causes some headaches.
Yeah, you're taking a huge risk if you do that, no doubt about it.
Yeah, you don't want to do that. By the way, when you die, you're not going to know any of this, and you're not going to be aware. All that knowledge that you have died with you. So encourage you to whoever you've named in these documents, sit down with them or have them go to suffer through some of the videos that we put together and have them take a look at it. It's important for your agent to know some of this stuff. I know when my dad died, if I would have known some of this stuff, it would have gone so much smoother and the family would have been so much better. Let's get to the Advanced Healthcare Directive. That's for medical decisions. Is it used for anything else besides that? Not really.
Not really. I mean, I guess if you include care, some care decisions that are, usually it's a combination of the durable power of attorney and the healthcare directive.
Yeah, for acute care, skilled care, and custodial care. This is what the person that you name as your agent is. So long as you cannot communicate, that's the key, isn't it, Steve? If you can communicate to the medical doctor, this document, your agent does not come into play.
Well, I tell clients this all the time. Excuse me. Look, if as long as you have the ability to make your own decision regarding your healthcare, it's yours to control. I've had some difficult situations come through my office where there might be an elderly parent who is complaining about a child who's named on the healthcare directive and the power of attorney, trying to, push through some decisions. And ultimately I tell the client, look, with my assistance or on your own, I mean, you have the power to make your own decision and you need to assert your own authority to the extent you're not happy with the decisions that your agents are making. And we can also make changes to these documents to the extent we need to take away power from someone who is not carrying out our wishes. But this is not, these documents are not written in concrete. So if you don't know how someone is going to behave until the time comes. You keep your fingers crossed and you've done your homework. You hope everything goes well. But if you get an indication that
all of a sudden they're not doing exactly what you wish them to do. Change the documents, find someone who will. And this is not a position of honor. This is work. And the agent needs to do what you need them to do, not what the agent wants to do. It's not about them, it's about you. And it's kind of like why we emphasize that booklet called Your Way. If you should have control over your medical decisions, you should have control over your death, where you want to die. It's your body. And if you want to let go of that control and give it to another individual, you can, but just so make sure that the other individual understands it, make sure that the other individual knows what you want, and so that you can have a comfortable and dignified death. We don't talk about it much, and we need to. It's part of life.
Yeah, I mean, the form itself gives some ability to lay out more detailed instructions. Like you said, there's the Your Way booklet, which is great. But a lot of times at the time, they come to me for estate planning. We do the healthcare directive. They've got some idea of, I don't want to be kept on life support if I've got no hope of recovery or this or that, but they often don't know the details. So I encourage clients to either have the conversations like what you're saying, or draft a letter to your agent or your kids saying, look, this is what I would like if we end up in this situation. It gives you a little more time to think about it. You're not under the pressure of, I want to get my trust done and everything else, and I really haven't thought it all the way through. So, even doing something after the fact that in writing can be very helpful.
Yeah. One of the things that happens too is that you're usually, do you ask for a half of the payment for your services up front? And then
usually not. Usually I request payment at the time I send out the first drafts of the document.
Okay. Well, a lot of times the document can't get completed until you know all the individuals that you're going to name in the document. So usually your attorney will want 2 to 3 people for the will. They want 2 to 3 people for your durable power. They want 2 to 3 people for your advanced healthcare directive, and they want 2 to 3 people under your living trust. Is it okay to name 1 individual or 2 individuals for all of the documents, or should you have different people for different documents?
I think for the most part, we usually have the same people in all of the documents, maybe with the exception of the healthcare directive. I'd say it probably should be the same people in the will, in the power of attorney, and the living trust as your successor trustees, executors, and attorneys in fact. But on the healthcare directive, sometimes clients have, maybe they have a child who's in the medical profession or that they think would be better suited to make some of these decisions. Or, I've even had spouses in my office saying, I don't think my husband's going to do what I want. So I'm going to name somebody else. That's a rare exception, but I've seen it.
It happens. It happens. My mother was basically the worst person my dad could have picked for making medical decisions. So because a lot of times you're under so much stress. And so therefore it's difficult for these decisions to be made. And medical doctors sometimes are in a hurry and a rush and say, hey, tell us what you want. And whether it's life support systems, morphine, whether it's to go on hospice and palliative care, that's its own terminology. We we have the a temporary right to die here in California, but you got to go through a lot of steps to do it. Have you had any clients that have taken that route, Steve?
I haven't had any experience with that. So
yeah, I haven't. I've heard a few people, and they said it went fairly smooth. So, but again, definitely needs to be discussed, and it'll make living so much nicer is the way I look at it.
yeah, the actual practical implementation of the healthcare directive and the medical decisions being made, it doesn't come across my desk very often. I'd say most of these issues are either resolved at the family level or someone makes a decision and that's kind of,
I agree. And therefore, give me two names and we move on so we can get you out the door with your estate plan. So it's really up to the individual to spend some time on the advanced healthcare directive because it's important. Let's go to the next page. The living trust. Probably here in California, New York, Florida, I would say pretty much most of us need a living trust. Why is that, Steve?
Well, it's because most of us, I'd say, probably own our home, at least one piece of real estate, and have some other items, and it's really the best way to avoid probate with the majority of your assets,
or to avoid a conservatorship.
Correct, and as you've especially have taught me over the years, and it's become my personal experience as well, is assets in a trust, the way I describe it to clients, is a trust kind of has a built-in power of attorney for assets that are owned by the trust. And for whatever reason, you could argue that there's not really a rational reason for it. A successor trustee taking over in the event of incapacity, banks and financial institutions don't provide nearly as much resistance to that as they do.
It's almost like you have it in one basket, and all your assets are in that basket, versus on a durable power of attorney, you have to go around and pick up each asset with the same document. I don't know if that makes any sense or not, but it's so much more convenient. Is there ever a probate between spouses?
Yeah, I mean, there's a probate procedure. It's a little bit different between spouses. It's called a spousal property petition as opposed to a petition for probate, but it still requires going to court. It still requires spending some attorney's fees to transfer those assets between spouses.
So if the spouses own separate property, but if they own everything together as a community property, would they still have to have a property spousal petition?
Yeah, they might. Yeah. I mean, assuming the asset's not owned in joint tenancy or community property with right of survivorship, California treats each spouse's half of community property differently. So even if spouses, and I don't even know it, you don't see it very often, if they were able to open an account that said husband and wife community property, and that's all it said, I think we would have to go to probate court potentially. Again, I don't think banks ever open accounts that way. So you'd see it. I've seen it on real estate though, where I've seen where it says husband and wife community property, either because it's an older deed or they left off the magic language of with right of survivorship, where we had to do a spousal property petition, which is like a probate between spouses, to probate the deceased spouse's half of the community property. So.
Yeah, so it becomes almost, when you get to be 70 and plus old, probably even younger, if you have assets, a living trust is just almost mandatory here in Orange County. It's a way to hold title to assets. And if something happens to the person who owns the property, the new trustee just steps right in and continues on and manages those assets. If you own property in more than one state, why would a living trust be of benefit there?
Yeah, it's because if you don't have a trust and you don't avoid probate for some other reason, you have to have a probate in each state where you own real estate. So, you'd have a probate in California. If you owned, a river property in Arizona, you'd have to have a probate in Arizona. So you end up with multiple probates for one estate, which is just not an efficient way to get the assets to your beneficiaries.
Yeah. If you're single, you don't have a spouse there to help you take care of things. Gosh, if you don't have it's almost a mandatory, get a living trust, because your successor trustee steps into your shoes financially and manages all your assets.
Pete,
so, yes.
The first bullet point under a living trust says fictitious way to have or hold title. Did you mean functional?
No, I meant it's that the trust is a paper. It's not something you can touch and feel. It's like a corporation. It's a trust is a statutory document. I'll probably be using fictitious. That's probably not the most
almost sounds like false
accurate description.
Okay. I mean, when I see that, when I see that word there, when I see that word there, the way I think of it is the assets are still yours. Yes. They're all taxed to you personally for income tax purposes. Nothing changes for income tax purposes. They're still treated as yours for almost every legal purpose. However, the actual ownership on title, is going to be in the name of the trustee of the trust. So that's when I see that word, Pete. I mean, that's kind of what I think of. Yeah.
Yeah. It's
that's because you're both lawyers.
Yeah. You don't really own the stuff any longer. The trust owns the stuff, and the trustee manages the stuff. So that's kind of why I used the word fictitious. But that's really important because, who do you pick as your trustee? Talk a little bit about that, Steve.
Yeah, I mean, the default for most families, most parents is, one or more of the children are kind of the first place that we look. However, if your children are still young, minors or young adults aren't responsible, then we're often looking to family members. I'd say probably more people should probably consider a professional trustee, especially if they have a complex situation or a trust company. But, I'd say, 95% of the time we're going with some trusted friends, family members, kids. And then another big decision that often comes up, especially for clients that have, multiple children, is should I have named just one of them as a successor trustee, or should we have co-successor trustees? And I think you and I agree on this point, Pete. The way I describe it is, being a trustee works better as a dictatorship than a democracy. And, for both practical and, ultimate decision-making processes, because when you have more than one trustee, unless the trust document says otherwise, they have to agree on every single decision. And there's also going to be probably some times where they need to be in the same place at the same time, whether it's to visit with the bank or sign documents relating to the sale of real estate, or which can be difficult if they don't live locally, or if one has a job that takes up a lot of time. So, these are some of the considerations.
Yeah.
Just so we're clear, while I'm living with my living trust, I can be my trustee. You're talking about successors, not because the first one can be me, or whoever the grantor is can be the trustee until they're either incapacitated or no longer here.
Yeah.
Correct.
Okay.
It's very rare that we're naming someone other than the person creating the trust as the initial trustee. I'd say sometimes when when parents get older and they want help from a child, sometimes we'll add a child as a co-trustee with the parent so that they can have access to write checks and help pay bills, things like that. But yeah, when I have a client who doesn't want to be the trustee of their own trust, I typically try and talk them out of that.
You want to stay in control.
Yeah.
You want to stay in control. You don't want to let somebody else get in control. But and make sure that, for kids, especially for children, I say children, usually the individual normally is between 50 and 80 years old who steps in as the successor trustee. So they're not kids. However, do they have the time? Do they have the ability? Do they have the desire? Do they get along and communicate well with your other children? The more children that you have, the greater likelihood there is maybe some problems occurs. If you only have one child, they're only going to have to argue with themselves. So there's usually not a problem. Let's talk a little bit about distributions, because that's probably the most important. Grandchildren, why should we think twice about giving to them?
Well, if we're talking about young grandchildren who are either minors or young adults, in almost every case that involves having money held in trust for their benefit till they reach a certain age, and there's administrative costs, trustee fees, accounting fees, tax issues related to that can make it costly, especially if the trust for the grandchild is not funded with sufficient assets to make it economically worthwhile to do so. My general preference is, unless there's a reason not to give it to your next generation, your children, is to leave it to your kids and let them provide for their own kids with what you've left them. Maybe a small token gift, just let them know grandma and grandpa loved you, here's $10,000 to each grandkid or something like that, can be nice. But if we're going to talking about big, large gifts to grandkids, I would put some thought into that before we do that.
Yeah. And a lot of, it's how much do you love me is based on how much you leave me. So, a lot of times a letter with your documents sometimes helps smooth over maybe hurt feelings. And I didn't name you because I didn't think you were competent. You lived out of the area, and that's why I didn't name you trustee. Or if unequal distributions, do you ever recommend that if one child is a lot wealthier than the other?
My recommendation, I try to encourage clients, if it fits their situation, to treat kids the same, regardless of circumstance. Now, there's always circumstances that sometimes dictate otherwise, but if you've got 3 kids, I would encourage you to leave it equally to your 3 kids.
Keep it simple, stupid.
If you're going to leave $5,000 to one grandchild, leave $5,000 to all the grandchild. I think part of this is trying to predict down the road, and your grandkids or your kids, they're going to have to live with each other or have a relationship after you're gone. And so why put this other element of mom and dad didn't treat us the same?
Yeah.
So maybe they didn't love us the same in there. And, Pete's, it's a good suggestion, the letter of why I treated you differently, but my experiences with those is they don't help. In the end, it's everybody's kind of staring at the number. Okay. I was given less.
Yeah.
The other thing is, in certain cases, I've seen it where, let's say I have 3 kids and I leave 2 of them 40% and the other one 20%, and maybe they have a good reason for doing that. Often I recommend either cut them all the way out or put them in for an equal share, as opposed to a lesser share. Sometimes fits the intended purpose. better is what I
Yeah,
found. But
in other words, have a discussion.
Yep.
There's no, if you're going to do an unequal distribution, think about it 2 or 3 times before you do it. Tax purposes, unless you're in the $20 million plus for a married couple, we don't need to do sub-trust any longer. Blended families, that's usually an issue.
Yeah, I mean, blended families are they're always very tricky. Even in the best cases, there's always, it's just it starts with a couple things. Like the first, and I run into this issue a lot where we have husband and wife come into a marriage. They each have separate property. They've each got their own kids, and so sometimes it's figuring out on the death of the first spouse, are we going to take part of the estate and give it to the kids immediately? Or are we going to leave it all for the benefit of the surviving spouse? And that can be kind of tricky to figure that out. I mean, I try to, especially for second marriages that are long-term marriages, I encourage the spouses to make sure they take care of themselves. Don't be leaving money early to either of your kids if it's going to force a change in lifestyle or your accustomed standard of living of whoever the surviving spouse is. Because I find that clients, even clients that are husband and wife and have separate property, typically while they're living and they're using those funds for their life expenses, they don't look at it as that's your money and that's my money. They look at it as that's our money, and that's what we both use to live on. So you got to be careful about taking too much of that away when the first spouse dies, just because you want to take care of kids by a prior marriage.
Yeah. Special needs, government benefits. If your child or one of your beneficiaries is a special needs individual, make sure you let the attorney know. Make sure that you coordinate that with your IRA account or commercial annuity. It requires a special trust and special thinking about it. If you have a spendthrift or an alcoholic beneficiary, you may be making it worse if you leave them a lot of money outright. So again, there's no one correct answer on this. Sit down and talk about it and see how you can use your estate or your money to help the individual.
Yeah, no, absolutely. Again, I keeping it simple, assuming that works in your particular family situation it works the best. It leads to fewer disputes amongst beneficiaries and trustees. So that's always the preferred. But, we recognize, or at least I do, that, every family has its own complexities and things that come in. And it's really, you need to make sure that you let your estate planning lawyer know if it doesn't always come out in our regular conversation about, do you have kids? And, when I'm talking to clients about that, I can only pry so far. If you anticipate an issue or, I don't know your kids, you do. If you think there could be some complications there, we should definitely talk about it and see if that's something we can plan for.
Yeah, you can't set up, or let me ask you, Steve, can you set up your own asset protection trust here in California?
Generally, no. I mean, you put the caveat in California. I hear about them in other states.
Yeah.
Courts don't, even the out-of-state ones or even the offshore stuff, which I am not an expert in, but courts do not like it when you tell them I can't get access to my own money because it's in a Alaska trust or a trust in the Cayman Islands or whatever. The bankruptcy courts are coming down pretty hard on those situations over the last 10 or 20 years. But yeah, a living trust, one of the big misnomers is it doesn't provide any asset or creditor protection for yourself.
Yeah, but you can do that for your kids. If your kids are having some marital problems or having bankruptcy problems or creditor problems, you can set up a trust for them that is protected from the spouse or from creditors. But again, it has to be done a certain way, and your attorney needs to know about it in advance and be prepared to pay extra. So, but it's there for you. Talk a little bit about distributing specific dollar gifts and percentage gifts.
Yeah, I tell all my clients percentages work great. You know, just it fluctuates as the size of your estate changes. So, you know, my preference is typically if we have, you know, 3 beneficiaries, you know, you can do, you know, 40%, 40%, 20%, or equally, they each get a third. If you do want to have a specific gift, like of a dollar amount, like $10,000 or $100,000, you know, my inclination is to keep those smaller, because, you know, I've seen many estates where it says I leave $100,000 to 5, you know, my 5 friends, and then my kids get the rest. And it turns out there is no rest or remainder,
Yeah.
you know, because the cash gifts get priority over the remainder percentage gifts. So a lot of my clients think about their estate that way. Okay, you know, Jimmy's going to get 400,000 and Bobby's going to get, you know, this. But ultimately percentages work better. There's also specific gifts of like of real estate, for example. Okay, I want, you know, my son to get the cabin in Big Bear, and I want my daughter to get, you know, the residence here. But you got to keep in mind that often those properties don't have equal value. So do we need to put in provisions to account for that, if that's really what ultimately is intended? My preference, again, you know, my mom going back, she had a couple properties, like, yeah, I got a property for you and your 2 brothers. And I told her, I said, Mom, just leave us a third each of the whole thing. We will figure it out. Okay.
Yeah.
You know, because I'm definitely a fan of that simplicity and letting the trustee and the beneficiaries ultimately figure it out. So
Yeah. Trust distributions take anywhere from 7 to 12 months, depending on the assets in the trust. In other words, if you had property in Palmdale, it may take a little longer to sell that property versus if it was here in Orange County. But a lot of people are under the belief that, hey, I have a living trust. I don't have to go through probate. So 3 months after a person's death, how come I don't have my money? And remember, get an attorney, especially on the second death. Talk a little bit about that notice that has to go out, and why is that so important?
yeah, so when someone dies and their trust goes from usually being, you know, a revocable amendable trust to being irrevocable at that point, the trustee has to send a notice to all the beneficiaries of the trust and also to the heirs of the decedent. So, for example, if one child was cut out of the trust, they get this notice, and probably the most important part of the notice is it says any beneficiary or any heir of the decedent only has 120 days to contest the trust. So it kind of forces anyone who might, you know, want to challenge that trust to do it quickly.
Yeah.
You know, otherwise the statute of limitations, I think, is 2 or 3 years on that. So we kind of like to, the trustees like to know. And go back to your comment. Yeah, I'd say most trust administrations take 7 to 12 months, maybe a little bit longer. One benefit to a trust is if all the beneficiaries and the trustee are on the same page. For example, let's say you have 2 kids, they get along, no trust issues. I mean, we can really move it along even sooner than that. Yeah. But that's the rare exception. But at least with the trust, it gives that opportunity if everybody gets on the same page.
Yeah. Taxes are no longer really an issue, like I mentioned before, but there is a provision that's still there, hasn't gone away. It's called the step up in basis. And so your assets receive a cost basis step up to market value on the date of your death. So which means that for most of your assets, you're not going to pay any income taxes if there's a sale right after your death of any of your assets. The only exception to that rule is what's called IRD assets. Explain what IRD assets are, Steve.
Yeah, so IRD, it's an acronym for income in respect of a decedent. So it's basically any tax deferred asset, and some of them are listed here. IRAs, 401ks are very common. And so, basically when someone dies, you don't escape the obligation to pay that deferred income tax that's built into the IRA or the 401k or the 457 or the annuity in many cases. So, and those don't get a step up in basis to avoid, any tax upon liquidation of those accounts.
Yeah. And remember, pundits are very, very rarely correct. When we put the outline together, the big news was that the step up in basis rule was going to go away. Well, that's not even being considered today. So the step up in basis rule is going to be there. And remember that tax laws do not make sense. They're a compromise of different opinions. And so you'll have crazy stuff in the tax laws and you wonder why they're there. And it's just because a compromise was reached to move the tax law forward.
Just to touch on a couple things, Pete. So you're absolutely right. So the infrastructure bill that was passed, it didn't change the step up in basis. The estate tax exemption is still 11.85 million, I think, per person. Yeah. So all that is still in place at this point, even though there was lots of talk earlier this year about that being changed.
Yeah.
But Pete, one thing I want to note in terms of taxes, it is important on first death that, and as Steve just said, there's a very large estate tax exemption, but one thing is portability. So if
talk about portability, Steve.
So portability just means that the exemption of the first spouse to die, the estate tax exemption, that $11.85 million is portable to the surviving spouse. So you don't have to do any fancy planning for a married couple to pass double the exemption amount, estate tax free to the beneficiaries. So it basically means that a married couple can pass, 23 million estate tax free to the beneficiaries. It used to be, and maybe some of the viewers still have these, we needed to do an AB trust or an ABC trust in order to preserve the estate tax exemption of the first spouse to die. But when portability was enacted, and Don, I want to say 10 years ago, maybe longer, it took away the need for those AB trusts or ABC trusts in order to save the first spouse's estate tax exemption.
But I believe that you still have to file a 706 on the first death to report that.
Yes.
That's absolutely true. So you do have to file an estate tax return to claim the portability. So often with my clients, we're kind of looking at the size of the estate. How likely are we going to need that extra exemption to cover the value of the assets? And if there's a chance, the client can decide to pay for an estate tax return so we can claim it.
Yeah, cost of an estate tax return averages anywhere between $5,000 to $20,000. So just to give you a clue, you don't want to do it if you don't need it.
Well, that tells me I need to start charging more for estate tax returns.
If yours is less, you need to do that. Let's go to the next slide or next page.
Sure.
These charitable remainder trust, they're just so overlooked by most professionals because most people don't think about giving away their assets to a charity. Most attorneys don't understand them. Most CPAs have never seen one. Most financial advisors are not familiar with them. And so with the particulars. But if you have a low cost basis asset that's highly appreciated, and you need income, you need cash, run the numbers. And Don, you're a credentialed Crescendo user, and have you been ever surprised at what the numbers look like?
No, I mean, it truly does what we keep talking about. And for all the one, I have no idea, 50 or more, whatever scenarios I've run through, it is surprising how beneficial these are. The tax advantages you get, the whatever, supporting charity, which certainly Pete and I believe very strongly in. But even if you don't necessarily have great philanthropic ideas, they're darn good tools. And you can send us a note and we'll be happy to run the numbers or ask somebody else to run them. But it's important.
Yeah, just run the numbers. It's you don't get a step up in basis until you die. So you want to save that asset for your kids so they can sell it without paying any taxes. You can transfer properties to a charitable trust, and inside that trust, you could sell that property with zero tax. It doesn't mean you have to give 100% of the property to that charitable trust. It doesn't mean that you can't get cash out of the sale. It doesn't mean that your kids are going to be disinherited. A lot of misconceptions are out there on a charitable trust. Recommend highly that you run the numbers, take a look at it, and see whether or not it fits for you.
I mean, we use the example, and Pete, I'll snag a few minutes on it. So Pete and I just finished closing off a trust. Last century, Pete was working with a client. It happened to be 1996, so I could say last century, with a client, and it was set up at that time. It continued to pay the couple until the second one died. At that point, it started a 15-year term to give the beneficiaries money. At the end of that, the money did go to charity, but they invested $1.3 million asset. And by the time the trust ended 25, 26 years later, they had paid out 3.6 million. So you can tell me that your children are going to kill you if you give it to charity. I'm going to tell you they're going to love you for the money that you may have earned for them over that time. So they are wonderful tools.
Yeah. Charitable gift annuity.
And Pete, we have 15 minutes.
Yeah. Charitable gift annuities are those kinds of tools for those individuals that don't like attorneys. It's a 2-page contract. It's pretty easy. It's a low minimum, $5,000. It doesn't give you any inflation protection, but if you need some, I had a gal who did Berkshire Hathaway stock, one stock, and she donated it to a charity in exchange for a charitable gift annuity, and she received something like 10% return income from that stock for the rest of her life. So it can work. It's not just philanthropic. Let's go into retirement funds. Beneficiary designation forms. Do you review those, Steve, for your clients?
Sometimes I'd say it's rare. We talk about them a lot, and who they might want to name as a beneficiary.
They should be coordinating who would they name in their IRA accounts and the 401ks with the living trust.
Absolutely. I mean, most clients are going to have assets that some pass by the living trust, some are going to pass by a beneficiary designation like retirement funds, and some might pass via joint tenancy, like between spouses or sometimes between children. So you just want to make sure that your beneficiary designations on your retirement accounts are consistent, or at least part of the overall plan with what you've done in your trust. And this sometimes comes into when we talked about earlier about trust distributions, making sure percentages, but you also got to take into account what assets that might pass outside of your trust to designated beneficiaries, just to make sure it all works to do what you want, at your passing. So.
Yeah. Let's go to the case study of the example. And perfect. Okay, we have an 80-year-old. She has a house. She has it in her living trust. Her cost basis $35,000, market value $750. She owns some Apple stock, and she bought it when she was young. Joint tenancy, she holds title as. Her initial purchase has grown to $100,000. She has an inherited bank account, and a fee means that it's in the person's own name. Cost basis is $300,000 and market value is $300,000. Cash cost basis is whatever it is, correct, Steve?
Yeah, cash is dollar for dollar. So
Dollar
yeah.
for dollar. Her IRA, she cost basis of $500,000 and it has a market value of $500,000 because anything you take out of an IRA account, whoever takes it out has to pay the income taxes on that. And she has her as her beneficiary designation, her estate. So my question is will any assets have to be probated? Let's go through the first one. First of all,
So
is this totally strange that somebody has assets like this?
no, I mean, it's common, people are a little bit, and often it's by inadvertence, they either beneficiaries were designated a long time ago, or they open a new account, even though they have a trust, they don't put it into their trust, or they acquire a new property. However, here the property is in the living trust. But no, it's not uncommon for people to have a mix of assets and how they're titled. I've said before in classes that, often the biggest part of a trust review, every 5 years or 3 years or 10 years is looking at your assets and how are they titled? Who are the designated beneficiaries on your various accounts or life insurance, just to make sure it's where we want it and that it puts you and then ultimately your beneficiaries in the best position to make everything happen quickly, efficiently, and with as little cost as possible.
Yeah. So more than likely, she should have had all of her assets except for her IRA in the living trust.
Correct. Yeah. All these are like your regular bank account, your stock or a stock brokerage account. Absolutely. My preference is to put it in the trust. Now here we have the Apple stock as JT, which is short for joint tenancy. I run into that a fair amount where someone wants to put a child on as a joint tenant just for convenience of being able to write checks. Typically wouldn't do it with the stock. Okay, we might do it with a smaller checking account if that's the intended goal here. But we don't know who the stock is in joint tenancy with. So let's say her living trust leaves it to Bobby, but the stock is in joint tenancy with Sally. There might be some inconsistency there. So you just want to make sure that all works out.
Okay. So first question is, will any of these assets will have to be probated? Which assets?
Yeah, so the house avoids probate because it's in the trust. The Apple stock will avoid probate because it's in joint tenancy with another person. Now the inherited bank account, because it's in the person's individual name and it's over that 166,000 exception, that will need to be probate. And then on the IRA, when you designate your estate as the beneficiary, or if you don't name a beneficiary, the estate is often the default under the IRA beneficiary forms. That means it's going to be probated. So here we have the bank account, and the IRA would need to go through probate.
So we have if she dies with this asset, so she has a probate estate valued at $800,000.
Correct.
Wow. So $800,000, the probate cost would be somewhere close to $40,000 if I can do my math correctly.
I think it's closer to 20, but yeah, okay. It's significant for what would be a very simple probate, 2 assets.
Yeah.
One's just cash. which could have been avoided.
Yeah.
And,
Okay.
and she has a trust. So
Yeah.
at some point she put some thought into not wanting to go through probate. So you just got to stay on top of your assets and how they're titled.
Yeah. She wants to make a $50,000 gift to her children. Which assets should she use? Most people that I've talked to about this, they pick out the Apple stock. Why wouldn't that not necessarily be the best asset?
If we're purely looking at it from a tax perspective, you don't want to give low basis assets to your kids because we lose out on the step up in basis. So if you give your kids the Apple stock, they get whatever your basis is while you're still alive. So they would get it, the $100,000 stock, but they would have this built-in capital gain of $99,500. Whereas if you die owning that stock and then they inherit it, they would get the Apple stock, and their new basis, new stepped up basis, would be $100,000.
Even though it's in joint tenants?
Yeah, there is that. You're right, Don. There is that quirky rule where you might get a half step up. But it depends who it's in joint tenant. If it's in with the spouse, I think we would still take the position that it's community property and gets the double step up. But if it's in joint tenancy with a child, then really she only owns half of it at that point anyway. But
there are a couple of questions that I'm going to put in now because we've only got 7 minutes anyway. Because it relates to this. If the bank account was in an individual's name, but there is a beneficiary listed on it, does it still go into probate?
Nope.
No.
It's called paid on death, POD.
Right. Thank you. That basically answers the three questions. Yes.
Okay. What asset should she use?
Well, here the only high basis asset, so to speak, is the bank account, which is cash. But yeah. I think, I see it a lot. People don't want to give away their cash. Cash is security. It's not
from a tax point of view, that would be the one to give.
That would be the preferred asset to give away.
Yeah.
Yes.
And would there be any gift tax on that?
There wouldn't. So that $11.8 million exemption, it's good for at death or during your lifetime. So there wouldn't be any tax due.
All she need to do would be to file an income tax return. No tax paid. Let's get to the next one. The house was left in kind to her two children. Her son is single, receives government benefits, and leaving the house to him would give him some place to live and have his sister take care of the house. The daughter, who's the CEO for a company that has $5 million in revenue a year, was named a successor trustee. Talk a little bit briefly about some of the issues that you see here that might cause you concern.
Yeah, so when it says the house is left in kind to her two kids, what that means is it's not sold first and distributed cash, that they become co-owners, partners on this house. And so, if one of the kids lives in the house and the other doesn't, do they have to pay rent? It just kind of sets up a situation for potential conflict. In most cases, I advise clients, let's let the trustee decide, if they want to sell the asset because it's easier just to distribute cash to the beneficiaries. And then secondarily, the son looks like receives government benefits. So that could cause some problems with, or maybe disqualify him from the government benefits he receives. Might want to consider whether a special needs trust will create the result that the client wants. And then secondarily, if the daughter is the trustee, she's now a trustee of a trust over which her brother is also a beneficiary. So, most of the time we try to avoid having, siblings be the trustee of another's trust. It's a recipe for conflict if one sibling has to go to the other to ask for money, basically. If she's CEO of a company with, she may not have time. People don't recognize as being a trustee or agent on a power of attorney. It takes a lot of time, especially in that initial period after someone passes away. That first year, 6 months to a year, it's a lot of work. Pete can tell you, this is what he does. It takes a lot of work in that initial time period to gather all the assets, figure them out, sell the assets, or file the tax returns, deal with the beneficiaries, do accountings, provide information. And I have lots of clients who have been trustees and they just can't find the time to do it. And it often gets them in trouble because they're not communicating regularly with the other beneficiaries.
Well, we have 5 minutes left. Why don't we take down the outline and put
Just as a
ourselves
note,
on the screen?
incidentally, if memory serves me correctly, if you left the house in kind, I think you have a bit of an issue because
Don,
California,
let me see your face.
No, you don't want to do that.
Yeah, I do.
It's ugly. I believe now in California, it would probably be reassessed for property tax. Because are they in fact using it as a primary residence, and what's the differential between value versus basis?
Yeah, no, the California voters in their infinite wisdom passed Prop 19 in the fall, which took away the parent-child exemption from property tax reassessment unless the child inherited it, moves into the house and makes it his or her residence. So
and dollar amount limitations. We've been answering the questions along the way. I've asked more questions than were asked. So we've actually done quite well.
Okay.
Yeah. If anybody has a question of Steve, he's on Zoom and he can't charge you. So it's a good time. It's rare you get an opportunity to do that.
Incidentally, one of the things that this is the last session of It's Your Estate. They're all recorded. I think there may have been one of them I screwed up and didn't do the recording. But otherwise, feel free to go back and look at them. Several people have noted along the way that they go back and review them, and it's very helpful. Trevor, who also has helped on some of these, made a comment that I talked too fast, and that he was reviewing one of them and trying to understand what I was saying. So that's generally why I'm the host. I am not the moderator.
I think you do a great job, Don.
Anyway, so going through this, I'm going to stop the recording.